Hi, I'm Dustin Saldarriaga, an immigration lawyer with Scott Legal PC in New York City. In this video, we're continuing our series on U.S. tax law as it applies to foreign nationals visiting the United States. In an earlier video, we gave an overview and explained how you don't need to be a U.S. citizen or even a U.S. permanent resident to be subject to taxation on your worldwide income by the U.S. government. We discussed the substantial presence test and how spending a certain amount of time inside the U.S. is all that's needed to expose your worldwide income to taxation by the U.S. government. In this video, we'll take a closer look at the tests the IRS uses to determine whether a foreign national is taxed as a resident or as a non-resident alien, the green card test and the substantial presence test. We'll also respond to a few common questions that come up, like whether a transfer at an airport or time spent commuting to an office in the U.S. counts as a day of physical presence for tax purposes. Before we get started, it's important to emphasize that the information in this video is not legal advice. We strongly recommend that you work with a qualified tax professional who can guide you through the specifics of your circumstances. Tax law is complicated, and a qualified professional can be a critical resource. With that, let's dive in. As a brief recap of our earlier video, the Internal Revenue Service, or IRS, is the U.S. government agency that's responsible for collecting taxes and administering tax laws in the United States. The IRS characterizes people inside the U.S. who are not U.S. citizens as either non-resident aliens or resident aliens. Remember that these are tax terms, not immigration terms. In other words, a person the IRS has characterized as a resident alien does not necessarily have a green card and does not need to be a permanent resident of the United States in an immigration sense. The tax consequences of being characterized as a resident alien instead of as a non-resident alien can be huge. While non-resident aliens are usually only taxed on income they receive from sources within the United States or from trade or business conducted in the United States, resident aliens are taxed the same way that U.S. citizens are taxed. This means that they're taxed on any income they earn anywhere in the world according to the graduated tax rates that apply to U.S. citizens. There are two tests that the IRS will usually use to decide whether a foreign national is a non-resident alien or a resident alien: the green card test and the substantial presence test. The green card test focuses on whether the foreign national is a lawful permanent resident of the United States. The substantial presence test focuses on how much time the foreign national is physically present in the United States within a 3-year period that includes the present tax year. Remember, a person is a resident alien for tax purposes if they meet either the green card test or the substantial presence test. Let's take a look at each of these two tests, starting with the green card test. The green card test is pretty straightforward. A foreign national is considered to be a resident alien for tax purposes if they are a lawful permanent resident of the United States at any point during the tax year. If you've been issued a green card, you're probably a resident alien for purposes of U.S. tax law. For the purposes of the green card test, you continue to be a permanent resident until the status is taken away from you or deemed abandoned. The IRS will usually want to see a final administrative determination or a judicial order before concluding that permanent resident status has been taken away or abandoned. Even if you are not a permanent resident, you may still be characterized as a resident alien for tax purposes if you meet the second test, the substantial presence test. To be taxed as a resident alien under the substantial presence test, the foreign national must have been physically present in the U.S. on at least 31 days during the tax year, and 183 days during the 3-year period in which the tax year is the most recent year. While the IRS counts days of presence during the tax year in full, in other words, being physically present for 32 days during the tax year counts as 32 days toward the 183-day limit, the IRS will only count 1/3 of the days the foreign national was physically present in the U.S. in the year immediately before the tax year. Similarly, the IRS only counts 1/6 of the days that the foreign national was physically present in the U.S. in the year 2 years before the tax year. To understand this formula, let's return to an example we shared in a previous video. George is not a U.S. citizen or a permanent resident of the United States. He's trying to figure out whether the IRS will tax him as a resident alien or as a non-resident alien for the 2021 tax year. In 2021, he was physically present in the U.S. 120 days. In 2020, he was also physically present in the U.S. 120 days, and in 2019, he was also physically present in the U.S. for 120 days. To determine whether George meets the substantial presence test, he would add all of the days he was present in 2021, 120 days, to 1/3 of the days he was present in 2020, 1/3 of 120 days is 40 days. He'd then add that number to 1/6 of the days he was present in 2019. 1/6 of 120 days is 20 days. The sum of 120, 40, and 20 is 180 days. Since 180 days is less than the 183 days that are required for a foreign national to meet the substantial presence test, George will not be taxed as a resident alien under the substantial presence test. 120 days was not chosen in this example by accident. As you can see, George barely missed the 183-day mark. Had he spent even a couple additional days in the U.S. over the past 3 years, he would be characterized as a resident alien, and his worldwide income would then be subject to taxation by the U.S. government. Similarly, foreign nationals can generally avoid tax liability under the substantial presence test by limiting their physical presence in the U.S. each year to less than 120 days. But what counts as a day of physical presence in the United States under the substantial presence test? For purposes of the substantial presence test, a day of physical presence in the United States includes any day in which the foreign national was physically present in the U.S. at any time during that day. For example, if you flew into the U.S. at 8 in the morning, attended a business meeting from 9 to 10 in the morning, then flew out at 11 in the morning, that counts as a day of physical presence. However, there are a few exceptions. The first exception applies to days when a foreign national is in the U.S. for less than 24 hours when they are transiting between two places outside the U.S. Such days do not count toward the 183-day substantial presence limit. For example, if you're flying from Colombia to London and you're in the U.S. for 12 hours while you change planes in New York City, that day would not count toward the 183-day limit. However, if you left the airport and attended a business meeting while in New York City, you would be required to count that day toward the 183-day limit since you're not in transit while you're attending the business meeting. Another exception is available for those who live in Mexico or Canada and regularly commute to work in the U.S. Days during which these individuals commute from their residence in Mexico or Canada to a workplace in the U.S. would not count toward the 183-day limit. The IRS considers someone to commute regularly when they commute to work in the U.S. on more than 75% of workdays during a defined work period. A commute is defined by the IRS as traveling to work and back to the residence within a 24-hour period. For example, Jessica is a national of Canada who lives in Canada and works for a consulting firm in Canada. Her firm is hired to advise a company located in the United States. Jessica is assigned to consult for the U.S. client company from February 1st to June 1st. For this period, Jessica drives from her home in Canada to the client in the U.S., then returns home each evening. She would not count days she commuted to work in the U.S. since those days were more than 75% of the workdays during the working period of February 1st to June 1st. Finally, a foreign national would not count toward the substantial presence test's 183-day limit those days during which the foreign national was in the U.S. as an exempt individual. This includes those who are present in the U.S. on behalf of a foreign government, teachers or trainees in the U.S. on a J or a Q visa, professional athletes temporarily in the U.S. to compete in a charitable sports event, and students who are in the U.S. on an F, J, M, or Q visa. Days in which a person is in the U.S. in one of these statuses would not be counted toward the 183-day limit. So let's say that you've taken a look at the substantial presence test and you realize that you have been in the US more than 183 days and are a resident alien for tax purposes. Is there anything else you can do? There might still be some options. Even those foreign nationals who meet the substantial presence test might not be characterized as resident aliens if they can demonstrate to the IRS that they have a closer connection during the year to a foreign country in which they have a tax home. This is called the closer connection rule. Importantly, the closer connection rule is only available to those who are physically present in the US for less than 183 days during the tax year. As soon as they're physically present in the US for 183 days, they would become ineligible for the closer connection rule. As an alternative, foreign nationals will want to consult any tax treaty that the US has with their home country. Tax treaties are treaties that the US has entered into with a foreign country that offers tax benefits to nationals of that foreign country who are present in the United States. Although resident aliens generally do not benefit from tax treaties, there are sometimes exceptions that would allow the resident alien to receive certain tax benefits. As a result, both resident and non-resident aliens should check any tax treaty that exists between the US and their home country. Below, we'll share a link where you can find a list of tax treaties along with their text. We hope this video was helpful. If it was, please click the like and subscribe buttons below to stay updated on future videos about visa options and travel to the US. Thank you for watching.